Before I formally begin my introduction, I just want to remind the judge of the first time I met him, for I'm sure he's forgotten. It was so awe-inspiring as to impress even the smallest of ants. I was a young student at the University of Pennsylvania, and his now current wife, Dr. Evelyn Brooks, as she was called then, was a faculty fellow at the dorm. And I often visited her and her young daughter, Nia, to hang out and get away from the rough and grime of undergraduate life. And one day, well, actually it was an evening, I went by her dorm room. It was actually a dorm suite, to see her, and Nia answered the door. "Hi, Travis, come on in." And I saw at the table in the living room this remarkable figure of a man. And the first thing I thought was, all right, what's going on here? Because usually she was involved in scholarly studies or watching television and so forth. And I'd heard so much about a legend that walked the earth, who was a trustee at the University of Pennsylvania and had traveled to South Africa on a number of occasions to try to help them get their minds together. And I approached this individual, and he began to stand up to introduce himself to me. And I saw that as he got to my height and continued, that he dwarfed me in more than just intellectual prowess. And he said, "Hi, my name is A. Leon Higginbotham, Jr." And in all of my articulate powers, I said, "You the judge." This is the man I had heard so much about. I'm sure that he was as unimpressed with my lack of control of the English language as I was impressed at his mere presence. I forget what we talked about because it was just a daze, and I went back to my dorm room and called the leader of the Black Student League at the time, who was Melissa Moody, and I informed her that I'd actually met A. Leon Higginbotham. She thought I was lying and hung up on me. Not too long after that, I took a course with him at the University of Pennsylvania, and he was gracious enough to allow seniors at Penn to take this course on the law and slavery. And it was very provocative and opened my eyes to many things, and I just wanted to thank you for that here and now. Thank you very much. Yeah. There's a dream in the land with its back against the wall. By muddled names and strange, sometimes the dream is called. There are those who claim this dream for theirs alone, a sin for which we know they must atone. Unless shared in common, like sunlight and like air, the dream will die for lack of substance anywhere. The dream knows no frontier or tongue. The dream no class or race. The dream cannot be kept secure in any one locked place. This dream today embattled with its back against the wall, to save the dream for one, it must be saved for all. Dream of Freedom by Langston Hughes. I started with this Langston Hughes poem because it is how this remarkable man, the Honorable A. Leon Higginbotham, Jr., ended his profoundly insightful, engaging, and passionate presentation, Justice Clarence Thomas in Retrospect, as a part of the Matthew to Briner Memorial Lecture Series at Hastings College of the Law on January 12, 1994. Some of you saw that broadcast on C-SPAN as I did. It was a very moving presentation, and Your Honor, I mourned with you as you tearfully recalled Justice Thurgood Marshall's final significant public appearance, encouraging us to keep up the fight for justice. I was overcome with emotion as you recounted how you opted not to use your judicial privilege to go in through the side door to view Justice Thurgood Marshall lying in state and then leave. You and your dear wife, Evelyn Brooks Higginbotham, went to the end of the line. It was a 3-hour wait for that opportunity to observe him. You spoke of the event that remained with you so clearly. In front of you, there were 2 men, poorly dressed for cold weather, you said. One was blind, and the older man said to the one who was blind that the casket was closed. And he started to describe the picture of Thurgood Marshall, and that people had put flowers and other things around the casket in honor of him. And as the man with sight described it to the man without sight, he said what Justice Thurgood Marshall stood for. And the blind man said, I see. Judge Higginbotham, I see. We all see that you stand for the same things that Justice Marshall stood for. Justice, equality, defender of the powerless, the people's advocate. Judge Higginbotham is a gifted teacher, a wise scholar, dedicated humanist, and a marvelous storyteller. He has garnered hundreds of awards and honors and has recently been awarded the Presidential Medal of Freedom, this nation's highest civilian award. A member of the Yale Law class of 1952, he holds over 60 honorary degrees from various institutions of higher learning. And if the Michigan Journal of Race and Law has anything to say about it, he will soon have one from the University of Michigan Law School. Indeed, our keynote speaker, please forgive me, bear with me as I get through this. Our keynote speaker is a giant and a true champion of justice. But more than that, he is also one of our true heroes, and not just a champion. The distinction is that a champion is carried on the shoulders of the people in recognition of his or her victory or accomplishment. But a hero that is a higher calling, because a hero carries the people on his shoulders. Surely, Judge, you are a champion. And sir, you are also a hero. It gives me the greatest pleasure to present to you the Honorable A. Leon Higginbotham, Jr.
I am profoundly moved by Travis's far too eloquent and glowing introduction. This is probably a time for confession. I am profoundly indebted to Travis. And how many students were in that dorm? About 100?
150.
150. I am profoundly indebted to Travis and the 150 students in that dorm, because, to put it in context, how did I meet Evelyn? I was asked to give a lecture with Lou Pollack, former dean of Yale Law School, former dean of University of Pennsylvania Law School, and now a judge in the district court. And Bob Ings, a history professor, had asked us to come to make a presentation. And on the day it was scheduled, I said, Lou, I can't do it. I was sitting the next day on the Court of Appeals. You go. I haven't had a chance to give a second's thought. And Lou said, Leon, you've got to go. Dash in, be there for 25 minutes, and then leave. At that time, we were asked a few questions. I thought we'd handled them quite well, and then a professor who'd just come to Penn said, well, let me see if I understand the historical context. Judge Pollack says this, and Genovese analyzes it this way, and Professor Stanley Elkins said that, and Judge Higginbotham, you have put a different shading on it. Now, how do you explain this in terms of the context of the Declaration of Independence, the July 2nd draft? Well, Lou Pollack's so much smarter than I am. He says, well, that's the colonial period, and that's Judge Higginbotham's field. I really didn't know what the answer was, and I said, you know, that's a difficult question. Why don't we chat after this meeting? And 2 years later, I was blessed to be married to Evelyn, and I think that she had great love for all of the students, like Travis and many others, but she thought that maybe sharing a house with me as husband and wife would be even as joyous as the 150 students whom she worked with. Well, I'm pleased to be here, and I want to make a few acknowledgments. At my age, I have trouble spotting people in the audience, but I understand Doris McCree is here. Where is she? Okay, fine. I have to acknowledge her first. There is no more gracious, no more compassionate, no more wise and giving and caring person. And I have fond memories of Doris and, of course, Wade, but she made a difference in the lives of so many people. And I think that you're fortunate to have her here. The second person whom I want to acknowledge, because I think that he, more than anyone else, is responsible for my coming to teach one semester here at Michigan. I didn't think it was that long, but Derek, your book has been out for more than 20 years. I hate to tell you. And so when I had the opportunity to write a review of Derek's book in the University of Pennsylvania Law Review, I tried to figure out what had been the deficiency in what was otherwise a good education that I received at Yale Law School. And the deficiency was the failure to focus on the significance of race and its continuum. The case book which I used had this to say about the Dred Scott. So the Dred Scott case decided in the 1850s is no longer relevant. And then they went on. And this was written by a professor who became a great friend of mine, a staunch advocate for me in getting lots of extraordinary opportunities. But Dred Scott was no longer relevant. So we never saw McLean or Curtis's dissent. We never saw Taney's majority opinion. And as I saw the marvelous texture of Derek's book, I tried to figure out what were the great cases which we had not learned in law school? And what I was concerned about was not merely the deprivation of a quality education to Leon Higginbotham, but these were the case books which influenced the individuals who were now making the adjudications in America. And therefore, this Brahmin expression, the eye cannot see what the mind does not comprehend, you had an absence of comprehension. So I took some of the key cases which Derek had discussed. I looked at the 1883 civil rights case. Many of the constitutional law books did not have it in. If they had them in, they did not have Harlan's dissent. I looked at Berea College, where the Supreme Court had held with Justice Holmes in the majority that the state of Kentucky could deny a private religious institution from educating students unless they would separate them and keep them 25 miles away. And I went through a whole series of cases, Cruikshank, Harris, Cummings v. Georgia, all of which became the core of extraordinary racial legitimization for deprivations. And what happened was that most of these case books did not have any reference, particularly as to the dissent of Derek's book. So I'd spent a lot of time on that article, and it had been out 2 weeks, and I got a call from the dean here at Michigan and said, "Leon, we'd like for you to come out." I said, "Can't come, Dean. I only am available on Saturdays, and you don't have classes on Saturdays." Dean says, "If you come, we will have classes on Saturday." I then said to him, "But I have to leave in the morning on Saturday. I don't want to leave on Friday." He said, "We'll fly you here first class Saturday morning." So because of Derek Bell's book, I came to Michigan for several Saturdays. They thought they'd have only about 10 or 15. I think we had a class of 60. And every Christmas I get many cards from students who were in that class. And yesterday I met a young lady who I think teaches immigration law here now, who had been in the Saturday class. So Derek Bell, I owe you a lot for causing me to get to Michigan and to move ahead. What's so important for what you're doing today and this weekend is that I hope that you will try to find time to talk to this extraordinary array of talent that the journal has brought. I had the pleasure of filing an amicus brief in Miller v. Georgia, and I had the obligation to read the record with care. There has never been a better record built, and there has never been a more thoughtful brief. And if you were going to decide a case on the compelling logic of the brief, Miller v. Georgia would have gone the other way, and the district would have been affirmed. But you are fortunate enough to have the lawyer who did much of the work in that, and for 25 years has been going in and out of the courts in Georgia, making a difference, accepting or being exposed to extraordinary abuse, but doing it with a calmness and a persistence which has made a great difference, and I'm very proud of him. Laughlin and Palmer. Please stand. Stand so they can see you. On October 30th, I will go into the district court in Shreveport, Louisiana, in behalf of Congressman Cleo Fields. We feel optimistic, but, you know, I always stay optimistic. And I think that we will have a good chance of getting that fifth vote. It's because of things that you've done for so long that we may be able to turn the corner. One of the people ask me, why did you leave the court when you got 65? I said, well, you know, for a long while I would meet people and they would say, Johnny, I want you to meet my teacher. Well, that's fine. And that worked well, and I dealt with that. And then one day, as I was walking across the street, a lady came in. I said, wait a minute, Judge, how are you? She says, Johnny, I want you to meet the person who taught your grandfather. Well, that's sort of a refreshing exposure to the years. Some years ago, I had the great honor of having Kimberly Kernshaw as one of my research assistants. I knew then she was going to make profound contributions to the law, and I'm pleased to salute her. Stand. I think you can almost make a compelling case that it's not how good judges are, but it's how wise they were in choosing extraordinarily talented people. My first law clerk was Eleanor Holmes Norton. When I hired her in 1964, before that, I was 35 years old as a district judge, and there had never been a woman as a law clerk in that district court. And thus they got a double shock. A black judge and a woman. And one of the greatest joys I have is the ability to look at individuals who are on such a profound cutting edge. And I want to acknowledge Steve Hawkins, a former law clerk who was with the NAACP Legal Defense Fund, handling capital punishment cases, who's now an advocate in trying to deal with these extraordinary problems, who's had the burden of arguing cases which, if the system were fair, he should have won, and seeing clients, through no fault of his own, have a tragedy. And for someone to be able to, year in and year out, face up to that extraordinary strain, when they could go to a law firm and make $90, $100, $200, $300,000, but they forsake it because of their interest of a cause of justice, they should be saluted. Steve. And Steve is part of a really extraordinary tradition. Gil Casalius, who's the chairman of the Equal Employment Opportunity Commission, Ron Noble, who's undersecretary of Treasury, and I could tick off many others. And each one is making a great difference. And I mention Steve, and I mention Kimberly, and I mention Ron Noble, and I mention Gilbert Casalius, and I mention Eleanor Holmes Norton, because I knew them when they were approximately your age. And they made a choice. And as tough as things are in this world, they are considerably better because of what they have done. I think that I've mentioned everyone except my colleague, Randall Kennedy. And Randy, it's good to see you. And we'll see you next week. Now, why am I here? What I had originally decided to do was that I thought that Travis, someone as tall as you and as tall as I am, you would get a podium so I could read what I'm about to say.
We tried to.
So when you have your next banquet, I want you to have a tape editor-in-chief, see how tall the speaker is, and then adjust. I had thought that my topic would originally be the United States Supreme Court, colorblind, race-conscious, or anti-colored. And I'm going to do that article because we have seen a cycle go through where the consequences is that we have not been colorblind when we should have in 1896. We have been anti-colored when we shouldn't have been in jurisprudence. And we now have, from Shaw v. Reno and a whole series of cases, something called race consciousness, which translated means anti-colored. But in view of the O.J. Simpson case, I felt that what I would do would be to try to comment on that case because it has some profound implications. I have never believed that professors were smart enough where they could not learn a great deal from their students. So when I was asked to speak in the evidence class, I think the professor and I talked about whether I talk about judicial notice, whether I talk about a whole series of matters in the federal rules of evidence. I said, well, I'll talk about any of these things. All I want to do is to circulate a questionnaire. And I circulated a questionnaire because if you want to understand what's happening in America, and if you want some sense of objectivity, I mean, you know, you can't go to Harvard because they are that way. And you can't go down to Mississippi because they are that way. So where you want to go is to where all of the normal people are. I mean, you know, that's what Newt Gingrich kept talking about. He said, you know, President Clinton doesn't understand the normal Americans. You know, people in Michigan and others. So I felt that here I am coming to the site of normality, that what I'd better do is to try to figure out something about the minds of the law students. And what better place to get an insight than to do it in an evidence class. So I circulated 6 questions. I didn't touch the papers at all. Wanted to keep it in line of command. All of those, you know, who were concerned about, was it to keep your chain of custody? It went from me to the professor to the secretary who did the tallying and came back with the answer. My first question to the best and brightest law students in America was as follows. If Nicole Brown Simpson had been an African American rather than being white, would the case have received just as much public and media attention? And I underline just as much, because of course it would have received public attention, but would it have received just as much? And if the wisest people say would not have received just as much, it means that race is a profound factor in America. And this is what this evidence class of 100 and some students responded. 58% said it would not have received as much public and media attention. 32%